Good morning, everyone. Sambhu sir, can we start now, sir?
Yes, sir. Yes, sir.
Sir, this is Mahesh. You can start, sir.
Okay. Thank you, sir. Okay, so good morning, everyone. Welcome to all to this 5-day workshop on the art of patenting and drafting, organized by EC Department, Madanpalli Institute of Technology and Science, Madanpalli, Chittoor, Andhra Pradesh. It is an immense pleasure that MITS has taken an initiative to organize a workshop on a title which is very timely. I extend my heartily welcome and gratitude to our today's expert and resource person, Mr. Soumya Jain, and faculty members and participants from various colleges, universities, and industries. So before starting the session, I would like to inform you all. You can put your queries in the chat box, and at the end of the session, we will take your queries one by one. So let's start the session. We're glad to have Mr. Soumya Jain. Okay, Mr. Soumya Jain is presently the examiner of patents and designs in the Indian Patent Office, Kolkata. He had completed his BE in EC from SATI, Vidisha, and later his MTech from Triple ITM Gwalior in VLSI design. Sir is having teaching experience more than 2.5 years in a college like LPU Jalandhar, MNIT Jaipur. He has prepared for and give interview to IES exam and various PSUs. So today, sir, will discuss on awareness on IPR and its domain. So I once again welcome to you, sir, and thank you so much for accepting our invitation. With your knowledge and experience, we will enrich our knowledge for sure. So thank you very much, sir. Over to you, sir. Now you can share your PPT, sir.
Yeah, thank you, Nanda sir. Thank you and good morning, a warm good morning to all of you who are present in the session. My name is Soumya, and as I have been briefly introduced to you all by Mr. Nanda sir, I don't feel the need to talk any further about me or the organization that I belong to, that is Indian Patent Office, Kolkata. And here with me today is also present my colleague and co-examiner, Mr. Dr. Kaushik Bagh, who is the convener of the program. And I would request him, if he listen to me, if he is able to hear me, to unmute himself and to start the session officially. Dr. Kaushik. Okay, so I think that maybe he has not joined yet, or maybe he's not able to hear us. Let's continue with the session for till then.
Yes, Sumo. Hello.
Yeah. Please, Kaushik. Yeah.
Hi. Good morning, all. This is Dr. Kaushik Bagh from Indian Patent Office, Kolkata. Actually, I have been the coordinator for this program from IPO program, IPO Kolkata, and we have been organizing this program under the banner of NIPAM, National Intellectual Property Awareness Mission, which have been carried out from I think in the month of November, December 2021. So I think Sir has been introduced Somo already. So without much further delay, I want to talk about 2 or 3 minutes about the IPR. So you know already that intellectual property is having different applications in economy as well as in Indian policy making. So we are focusing on the intellectual property to learn from it, to apply it in our daily life. And so we are targeting students as well as faculty, mainly the academic coordinate of our actually academic coordinate of our society, so that they can eager to file much more intellectual property. They can register and they can get benefit of their IPR, their intellectual properties. So targeting that, we are organizing various lectures on that. And as per EC, Department of EC, MITS, they have invited us, actually invited to talk about patents. But actually, we are not so specific about just patent. So we will talk about the IPR. Some will talk about the IPR, and then we will move on to patents. And if required some searching, we will show how to file it. Some specific slides will be there in the domain of patent. So I will request you to be attentive in the session, and later on there will be an interactive session, and there will be question and answer. I am supposed to be here up to, I think the program will continue up to 12, but in the meantime you should have learned like the intellectual property, about intellectual property, and then we will move on to another domain of IPRs, other domains of IPRs. So let's start the program. I will like to thank Dr. Mr. Somo Jain, who is at IPO Delhi right now. He has been transferred to IPO Delhi for his excellent performance and something like that. So he is an excellent speaker and eminent speaker, and he is always there with us in the NIPAM program. So I would like to thank him for agreeing to deliver the lecture in spite of some difficulties there in the IPO Delhi. So let's start the program. Thank you so much.
Thank you, Kaushik. Thank you all for bearing with us for this short introduction. Now we will get to the point. First, I would like to thank the organization and the organizers of this workshop, APD workshop, that is Art of Patenting and Drafting, that has been organized by Department of ECE, MITS Madan Balle, because this field is very hot field in today's world. Whatever you are studying for 4 years of BTech, all that the technology that you are studying and that you may develop in future, you may be developing right now, it all needs to be protected. And in today's world, if you have to earn profit, if you have to progress, the thing IP is a very important, one of the most important things that must accompany the field of technology, that must accompany the field of engineering. So if you are an engineer, if you are a doctor, if you are a technological person, if you have knowledge of technology, if you make new inventions, it is very imperative of you, it is very necessary for you to know about what IP is, intellectual property is, and especially what patents are. So because we are organizing this workshop under NIPAM, NIPAM, NIPAM stands for National Intellectual Property Awareness Mission, and today is World Intellectual Property Day, also 26th of April. So it is our duty to start the session with basics of IPR. So I will cover the topics briefly: what IP is, that is intellectual property is, what IPRs are, that is intellectual property rights are, and then among those IPRs, one of the IPRs is patents. Then we will go in depth of patent and see what patents are. So I would request you if you have any doubts, I will ask in between the session about your doubts, and at the last of the session we will have a Q&A session so that I can clear all your doubts, whatever doubts you have during the presentation. Okay, so let's get started. First, outcome of the webinar. Let me discuss about the outcome of the webinar. First part and second part, there are two parts of the webinar. First is general IPR session, second is patent basics. So in part one, we will discuss about the concepts of IPRs, various IPRs, that is patent, etc. patent, design, copyright, trademark, geographical indication, and SICLD. SICLD stands for Semiconductor Integrated Circuits Layout Design. So as you can see, part 1 is the general introduction of IPRs. There are 6 or 7 kinds of IPRs that are there, and we will discuss them briefly. The second part of the IPR, the second part of today's webinar will be about patent basics, that is understanding patent literature and non-patent literature. As you all come from the academic background, I'm starting this patent part from the difference between non-patent literature, as you may be aware of already, conference papers, journals, etc. Non-patent literature or academic publications. So comparing those academic publications with patent literature, what is the difference between the two? Then we will come to see the basics of patent drafting, patent filing procedure, patent search techniques, use of patent literatures and R&D, latest trends in patent and other IPRs, and research practices to manage disclosures. Means if you are going to file patent, what are the things that you must keep in mind if you are in the R&D field? Okay, so we will be covering this. Now coming to the basic introduction part, this will be a very short introduction. It will be about for 20 to 25 minutes. Okay, so let's start with the background of intellectual property. So what is intellectual property? We all know about the basic definition of property. What property is? What is property? Property is something that you own, that you can use, that you can rent out, that you can sell, that you can purchase, etc. Anything that, if you own some property, it can be used for your own use. You can sell it, you can license it to another person, you can give it for some time to other person to use it, etc. So you have some rights over your property. Now property is basically of 2 types. First is tangible property and intangible property. Second one, tangible is something that can be measured, that basically you can see with your eyes. For example, if you have tangible property, again, is of 2 types, movable and immovable. So tangible property such as car is a movable property. You can own a car, and similarly the immovable property like building, house, etc., smartphone, etc. are there, that you can own, that you can purchase, that you can sell. There are a whole lot of rights that are associated with the properties like cars and buildings. Similarly, the other kind of property is intangible property. Intangible property basically is intellectual property, because you can't see it, you can't feel, you just can, and you can develop it. What is intellectual property? Intellectual property is a kind of intangible property, that is immeasurable property, or that which cannot be seen with the eye. And how that property is developed? The intellectual property is developed by the application of mind or application of intellect. So whatever property is generated by us humans by the application of mind, by the application of brain, okay, is called intellectual property, and it is a kind of intangible property. Now intellectual property again is of 2 types, industrial property and copyrights. So industrial properties are patents, designs, trademarks, GIs, which can be used and applied in industry. Whereas copyrights are there. Copyrights are something that copyrights are properties, rights which are given on properties that are intellectual property, but that cannot be implemented or that cannot be used in an industry. For example, you may copyright a book, you may copyright an article. So that copywriting of a book, of music, of article, of cinematographic films cannot be used in an industry, cannot be produced in an industry. That's why they are non-industrial properties. Okay, so this was a basic idea or sketch of what intellectual property is. Now coming to the definition of intellectual property is a property that arises from human intellect. It is a product of human creation. So it is a product of mind. Simply, you can say it is a product of mind. So, okay, so when you have some intellectual property, what you can do with it? So you have certain rights. There are 3 rights that are given on this slide. First is you can protect your property. That is, if you have a patent, for example, if you have a patent, then you can protect it. That is, you can use it for your own purposes. You can do further R&D on that particular thing. And second is exclude others. If you have a patent, for example, you can exclude others from using that. If you have a patent over a smartphone, then if you can exclude others from making that smartphone, you can exclude others from selling that smartphone. Okay, so that is some right that you achieve by taking that intellectual property. And third is utilize, commercialize, and earn. So you have the right to utilize that property, you have right to commercialize that property and earn profits out of it. Okay, so these are the things that you can do with intellectual property. Now, here 6 basic kinds of intellectual properties have been listed in this slide that we will be seeing in the further slides. What are they? Patents, designs, trademarks, geographical indications, copyrights, and SICLDs. Now, before moving to the individual IPRs, first I would like to tell you that there is a possibility that a product is there and that one product is protected by not one IP, not one IPR, but multiple IPRs. For example, in this slide, you can see an Apple laptop. Okay, there is a MacBook you can see, and on this MacBook has multiple things, multiple facets that are protected by different types of IPRs. For example, the logo of Apple, as you can see, can be protected or is can be protected by a trademark, while the design, whatever you can see, the body of the laptop, the shape of the laptop, the color of the laptop, etc., is a matter of protection of design. Okay, and the LED technology behind this laptop, or the LED display, how that display has been formed, is a matter of technology. So technology is basically are always protected by patents. So LED display will be protected by the patent. And this laptop comes with some user manual. So user manual has English. It is written in many languages, and because it's a text, so it can be protected by an intellectual property right, IPR, called copyright. And there are certain ICs also inside this laptop. The ICs or SICs, that is semiconductor integrated circuits, the layout of those circuits can be protected by the SICLD, that is SIC layout design. So layout designs are different kinds of, is a separate class of intellectual property that can be protected. You can protect if you have designed, if you have a layout of some IC, you have designed that layout, you can get it protected in by SICLD. Okay, so these are the, so I am what we have tried to show in this slide is, even in a single product there are many things that have to be protected by different categories of IPR. It is not necessary that one product will be protected by only one IPR. Now coming to patents. What is patent? Patent is a grant of a sovereign or a state to a person, giving exclusive right to stop others from making, using, exercising, vending, and importing. What do we understand by this language? So what do we understand by this language? That is, patent is an exclusive right. What is exclusive? Exclusivity, that only one person, the patentee, the applicant of the patent, is only the sole proprietor of that right. Okay, it's an exclusive right. What does that exclusive right include? It includes, it stops others from making, using, exercising, vending, and importing a product. So agar aapka, if you have patent over something, then you are the sole proprietor of that patent. You will be eligible to use that product or do whatever thing you want to do with that product, and you can stop others from using that product. You can stop others from making that product, from selling that product, from exercising that product, or from importing that product also. Okay, so why do the governments give patents? Because what is the utility of giving a patent? It is that the knowledge that the applicant has, the knowledge that the inventor has, should come into the public domain, so that there is a rapid growth of R&D in the country. So in exchange of the disclosure, in exchange of the knowledge the applicant gives to the government provides an exclusive monopoly or exclusive right to the applicant to use that particular invention, whatever invention the inventor has made, for a period of 20 years. So if you have invented something, you just disclose how you have made that invention. In exchange of that complete disclosure to the government of India, to the patent office, we will provide you a grant of 20 years of sovereign right, that is exclusive right, that you are the sole proprietor for the next 20 years. Nobody else will be able to sell it, manufacture it, import it, or use it. Okay, so this is what basically patent is. One more thing about this is patents are sovereign, or patents are territorial rights. What do you understand by territorial rights? Territorial rights are which are applicable for a particular region or a territory. So India is a country, is a sovereign country. If you are applying for a patent in India, that means that even if that patent is granted in India, that does not protect from that does not protect any person from using your product in any other country outside India. So if you have patented your product in India, one may use that product in US, one may sell that product in US if you have not got a protection of, or if you have not got the patent of that product in US, in EP, in Japan, and all the other countries. So it is a territorial right. If you want that product to be protected in all the countries, then you will have to separately apply for that patent in all the countries, in all the territories. So you got my point? Let's move on. Some famous Indian inventions. In this slide, we have discussed about 3 inventions that are very famous world fame inventions that have been patented in India. For example, nano car, that was one of the cheapest cars. Hepatitis vaccine. Hepatitis vaccine is 40 cents a dose. It's a very cheap vaccine that has been made by an Indian company, okay, and has been given a patent in India. Jaipur foot, prosthetic foot, that just costs about US $28. It's affordable prosthetics, and it is made in India, and it has been patented in India. Now coming to this was about patents. This was about the first basic IPR that we discussed was patent. Now we come to designs. What are designs? Sometimes it's called design, sometimes it's called design patent. So don't confuse between these two terms. Patents are separate thing. Design patents are separate thing. Either you call it design patent or you call it design, they are one and the same thing. Okay. So what does design do? Designs now from this slide, slides we may provide you later. So it's not we don't need to read the rest of the slide. What we just are here to discuss what design is basically. So design is the aesthetic part of the object. So you can see there is a sari, there is a fan, there is an alarm clock. So the aesthetic point of view or aesthetic sense of that object is covered by what you call a design. So there are 4 kinds of shoes. As you can see, 4 kinds of bellies are there in the slide shown. So each one of them has a distinct design and color and appearance and so on. So design protects something that is solely judged by the eye, that is appealing to the eye. Whatever you can see through the eyes, the color, the design, the pattern, the shape, that is the criteria of, or that is something that is protected by a design. You can see various kinds of handbags also of different designs, different colors, different patterns, different shapes. So all these things are a subject matter of separate designs. So if you have made something that is appealing to the eye, if you have so you get the design patent first. So in the case of Apple, the shape of the Apple iPad, the shape of the iPhone, etc., that is a particular shape, and no other company can. And iPhone has got the protection of the design of that iPhone, with the shape of the iPhone, the look of the iPhone. So no other company can copy the same look of the phone. So if OnePlus, Samsung, etc., any other company tries to copy the shape, tries to copy the color of the iPhone, then it will be an infringement of the right that the Apple has. What right Apple has? Apple has protected the design of the iPhone. That is, Apple only can be using that particular design. No other company is entitled to use that design. So shape, configuration, surface, pattern of bottles. In this slide, you can see different kinds of bottles, different shapes and colors of bottle. So this is all what the design covers. Now coming to trademarks. Third category of marks is trademarks. What are trademarks? Trademarks are the concept. First, let us see the concept of trademark. Trademark is any word, any name, any symbol, or any device, or a combination thereof. And what does it do? It identifies and distinguishes the source of the goods or services of one trader from those of the other. So what means this may be the definition of what trademark is, but what is the function or what actually trademark is, we will see in the next slide. First, let us see the function. It provides exclusive monopoly over a class of goods or services, and it identifies the source or origin of goods and services. So for example, let us see in this, there are, what is the subject matter of trademarks? You can see various trademarks on the right side. There is a logo of Google, a logo of McDonald's, Coca-Cola, Adidas, Nike, Ye Dil Mange More, that is Pepsi, Naukri.com, Columbia Films, etc. What you can see or what you can observe, these are all trademarks. So now we can understand what trademark is. What trademark is? Trademark is any word, any symbol, any device, or a combination thereof, which is used to distinguish the products of one company or the products of one source from the products of the other source or other company. So it is very easy to understand now, because you can see two competitors or two big brands of shoe manufacturers are there, Nike and Adidas, and you can see the logos or the symbols of both these companies in this slide. Now, if any shoe is there and you see a right take over it, you understand that this has been made by Nike. While if the Adidas logo is there, you understand that this shoe has been made by Adidas. So what does trademark do? Now you understand what does trademark do. It distinguishes. It helps us to distinguish the products of one company from the other, and it establishes the brand value of that product. So Nike and Adidas, for example, McDonald's is a brand. If you see a McDonald's logo over a box of burger, then you understand that there is a certain assured quality in the burger that you are eating. Okay, so it is used to create a brand value. It is used to distinguish the products of one from the other. It assures the customer about the quality of goods and services. And one more thing, it allows a business entity to build up public goodwill and brand reputation. Okay. One other thing means, if some other products are there and they make logos similar to Nike or they make logos similar to Adidas, then they will not be permitted to use that as a trademark. They will not be granted trademarks for that, because trademarks should be separate from each other. They should not be identical, so that it is easily distinguishable, and no copies or no pirated products are possible. So it is always preferred that the trademark, the logo, the trademark of one company should be very much different from the trademark of the other companies. So in some recent trademark infringement cases, you can see, for example, Decathlon is one of the famous sports goods brand in India. So Pentathlon, another sports brand, is there. Pentathlon, the name is similar to Decathlon. So Decathlon had a trademark over its name. So it went to the court and told the court that this is a similar trademark and it is infringing on our right of the name Decathlon. So nobody can keep a name similar to Decathlon. Okay. So this is how, this is what the importance of trademark is. Another example is, there was also a case between PhonePe and BharatPe. So PhonePe told that PE-Pay cannot be used and should not be used because it's a trademark of PhonePe. No other company should, in payment zone, can use PE-Pay word in its name, but BharatPe is there and BharatPe uses this. So there was a court, PhonePe went to the court against BharatPe. So this was about third IPR. Now coming to copyrights, which is the fourth IPR. Fourth, and what it is, what is copyright? Copyright is anything that is non-technical in nature. That is non-technical in nature can be protected by a copyright. Copyright में क्या-क्या protect हो सकते हैं? The subject matter of copyrights that we will see in the next slide. What are the criteria for the work to be copyrighted? There are three criteria. That is, first is creativity, second is originality, third is fixation. So what is creativity? If you have something, if you've created something out of the creativity of, by the application of human mind, by the application of brain, anything creative, if it has creativity, first criteria is met. Second is originality. The work that you want to copyright must not be copied from anywhere else. So if you have written a poem and if you find words of that poem similar to some words of the other poem, then it cannot be copyrighted. It will be rejected as copyright. So it should be original work. Third thing is fixation. Whatever, if you have met the first criteria, that is, you have something that is creative, you have something that is original, but you have not put it in concrete terms. That is, if you have some idea, some poem in your mind, that poem is creative, that poem is original, but if you have not written that poem on a piece of paper, then it has not been fixed. So it is necessary that the work should be fixed, should be tangible, we should be able to see it. The others should be able to read it or should be able to view it. So if the work matches these three criteria, then that work can be a subject matter of copyright. Non-patent literature, NPL, can be copyrighted. For example, if you published a paper in any of the conferences or journals, it is your work because it has creativity, it has originality, and it has been fixed in the paper. That's why you can get a copyright of it. And certainly all these big journals and conference papers which are published are already copyrighted material. No one can use that copyrighted material without asking for the permission of the copyright owner. Now, what are the subject matter of copyright? Literary works, dramatic works, sound recording works, artistic works, musical and cinematographic films. We don't need to go into details of this. Basically, copyright is for those who belong to arts backgrounds and in the fields of drama, music, sound recording, literary and artistic works, etc. There are multiple cases. For example, you must have heard about this, or you may have used this site, Sci-Hub site, with different extensions or different in different countries, like TW in this case, stands for Taiwan. So Sci-Hub is facing this copyright issue that it provides the material of all the non-patent literature across boundaries. But that non-patent literature has been copyrighted by different publications. So it is an infringement of the copyright of those owners. That's why Sci-Hub has been banned in India and in almost all the countries across the world. Now coming to SICLD. SICLD are, as I told you, semiconductor integrated circuits layout design. So there is an SIC or there is an IC. You can see the placing of the different modules, the placing of the different elements on the board is called the layout design. And if you have made that layout design in VLSI, then that can be protected by SICLD. The office of the SICLD is in Delhi, registry is in Delhi, and the period of registration is 10 years from the date of application filing or first commercial exploitation, whichever is earlier. So if you have designed a layout and if you have taken a protection of that layout, you will be entitled to use that layout exclusively for 10 years. After 10 years, it becomes public and anybody else is also free to use that. Now coming to the last the IPR that we will briefly discuss is geographical indication or GI. What are GI? These are invaluable treasures of incredible India. What does it mean? Let's see in the second slide. Now take for example Kanchipuram silk, or for example Darjeeling tea. All of you must have heard about Darjeeling tea. Darjeeling is famous for its tea bagans. Okay, so what is GI? GI is basically if a thing is produced, if a certain product is produced in a particular geographical location, then due to the geographical origin of that location, it possesses certain qualities and a reputation in the market due to that origin. Therefore, the product that comes from that origin or that comes from that particular geographical location is given a tag, GI tag, that okay, any tea that is grown in and around Darjeeling will be given a GI tag of Darjeeling tea, so that the customer who is purchasing the tea knows for sure that this tea has been made in Darjeeling, and the Darjeeling tea is superior to other kinds of teas across the world because of its geographical origin, because of the environmental conditions across around that particular place. Okay, so this is there are many in different states. There are many different geographical indications that are famous. For example, Bhagalpuri silk in Bihar, है ना, Magahi pan in Bihar, etc. Now coming to the validity of various IPRs, term or validity of patents, you get a term of 20 years, designs 10 years, which can further be extended by 5 years. That is 15 years in total. Trademarks, indefinitely subject to renewal. So initially for 10 years, after that each year you have to renew the trademark. Geographical indication, indefinitely subject to renewal. Initially for 10 years, then you can renew it indefinitely. And copyright is up to lifetime of the author plus 60 years. That is, if I have created some work, it will be protected throughout my lifetime, and even after my death, it will be protected for a term of 60 years after my death. So this is what the term of copyright is. Who can apply for these IPRs? Persons can apply, or person or their legal representatives can apply. This includes firms, this includes partnership firms, small entities, corporate bodies, companies, etc. Okay, so one more thing, GIs, that is geographical indications, cannot be applied by persons. They can only be applied by legal bodies, legal representatives, and firms only. As this point, last point, all IP rights are territorial in nature. This has been discussed already in the previous slides. Now we reached at the end of the first part of the webinar, that was on the basics of IPR. Now we are moving to the second part, and which is very important for all of us. We wanted to, we are excited for moving to the second part of the webinar, that is about patents, specifically about patent basics. And the points that we will be covering in the later slides will be understanding patent applications, difference between patent and non-patent literature, what to patent, legal requirements of patentability, that what are the things that you have to fulfill, legal requirements that you have to fulfill for the material or for the invention to be patentable. And now, what are patent filing requisites? What are the things that you have to keep in mind before you apply for a patent? Patent application drafting, how to draft a patent application, fee schedule and filing procedure, what will be the fee structure if you file for a patent, and what will be the filing procedure. Publication search strategies, if you want to search for a patent publication, how to search for it, or how to search for prior art, or literature review, how to do literature review for patent publications. And 9th point is research practice to manage disclosures. If you are applying for a patent, if you have taken help of, if you are planning to file for a patent, what are the things that you have to keep in mind about disclosure, that you have to protect your invention from getting public before you publish it, before you apply for the patent. So that will be the 9th point. And last is the latest trends in patents and other IPRs. What is the current trend of IPRs and patents in India? So let's take a small break. Before moving to this part, I will just ask for all of you who have been part of this webinar till now, if you have any doubts, you can ask me. If you can put it in the chat box also. If you have any doubt till now, I will try to clarify it, and then we will move ahead. If you don't have any doubts, then we will move ahead directly. Anyone? You can raise your hands. or you can put it in the chat box. Okay, I think nobody has a doubt till now. Okay, in that case, we will move ahead with the part 2 of the today's webinar, that is on patents. Okay. Okay, so first thing is understanding patent applications. Understanding patent applications. So you all must have seen some patent applications. If you have not seen any patent application, I would request you to go to Google Patents and search any term, search whatever you feel you are. If you are all from electronics communications background, then you can see a smartphone. You can see for user equipment UE in communications. You can see base station. You can see any field that belongs to communication, any field that belongs to converters, any motor, induction motors, or all these kinds of controllers, PID controller, PD controllers. You just put that search term, there will be n number of lakhs of patents that will appear in front of you. You just click on one, you will be able to see how a patent looks particularly, and the contents of the patent application does not differ much from country to country. So if you see a US patent, you see a European patent and an Indian patent, a Japanese patent, there are some basic differences between the syntaxes, how the text has been arranged, what will be the font size, etc. These differences are small differences. Apart from those small differences, the contents are almost same. As this is similar to the case of non-patent literature. In academics, you publish different publications, different journals ask for your submission in different formats. So this is similar to the patents in different countries. Now, if you look at a patent application, what are the things that you to see to understand that patent? First thing, what is the problem statement being discussed? So when you see a patent, we will discuss what are the contents of the patent application. So when you see a patent application, there will be a background of invention, there will be a field of invention. So in the field of invention and background of invention, you will see, you have to try to understand what is the problem statement that the applicant is trying to solve. Problem क्या है वो हमें identify करना होगा. The second thing will be the solution that was previously available to the said problem. Once you have identified that this is the problem, now there are in the prior art, in the literature, you have to understand in the patent application, it will be mentioned that some people have tried to solve this problem and the solutions that were proposed by those persons are these. So alternate solutions to the problem will be identified therein. Again, drawbacks of the previous solution. In all those solutions that had been previously disclosed by prior arts, there must be some gaps. There must be some problems or drawbacks. And the new solution that you are trying to propose in your patent, how that solution is fulfilling the drawbacks or covering the drawbacks of the previous solutions, you have to tell it. So in understanding a patent, you have to do all these four. You have to do all these four steps sequentially. First, identify the problem statement. Then identify what are the solutions that have been previously proposed. Then identify what are the drawbacks in the previous solutions. And now, what if you have a new suggestion, if you have a new implementation or new idea, how that new invention is fulfilling the drawbacks or of the previous solutions, or how it is better than the previous solutions. So now, when we discuss all these 4 points, you must be thinking that it sounds similar to my IEEE transaction paper. What is the difference between patent and non-patent literature? So in the next slide, we will discuss about what is the difference between patent and non-patent literature. So on the we discuss on the left side, it is about the patent publication. On the right side, the second column is non-patent publication. First criteria is content. So in patent publication, the content is technical solution to a problem, and non-patent publication, it is mainly basic research findings. So to understand this, the content, the basic difference between a patent and a non-patent literature, NPL, is that in non-patent literature, in the conferences or journals that that academicians publish, whatever new research you are doing, even if that research cannot be directly implemented in the industry, for example, you have made a new nanomaterial, or if you are researching in the field of material science, you have made you have searched for a new kind of insulator material, for example, or you have invented some kind of a new ceramic material. Now this new ceramic material, that it will have a thermal resistance of this much amount, if it will have these properties, all these new findings, new searches, new research, you can publish in a non-patent literature. You can publish, go to a material science journal and publish it there. But in a patent, the subject matter of a patent is about a problem, a technical problem, and how to solve it. So if you have made a new material, it is not directly patentable. How you can get a patent of that particular thing? You have to, if you have invented a new material for making an insulator. So the subject matter can be a new insulator material, means a new insulator using a new material. So आपने new ceramic material for use in capacitors, a new insulator material to use in capacitors. This can be the subject matter of the patent. Now, the problem that you will be identifying is in the previous materials that are used in capacitors. This was the problem, and now the new material that I am using, this is one of the better options of using of this is one of the better materials as compared to the previous materials. Therefore, patents are technological things, engineering things. They don't apply for the sciences. If you have a new science, if you have a new discovery, you don't get a patent for it. You can get a patent only for a thing that is a new kind of engineering. If you are making a new capacitor using a new material, then you can get a patent for it. If you just make a new material, you don't get a patent for it. So I think I have been able to articulate what the difference between the subject matter of a patent and the subject matter of a non-patent literature. Now, second point is access. How to access a patent publication through patent databases, and how to access non-patent publication through open or paid access journals. So IEEE, Elsevier, Science Direct, etc., ACM, etc., are all the journals that are paid journals. There are some free journals also. So you have to access them individually. Similarly, in patent publication can be searched or can be accessed with the help of free open source databases as well as paid databases. So we will be discussing in later slides what free and paid databases are available for patent searches. Plagiarism check. This is one of the important things to keep in mind, that plagiarism check is not done in case of patent applications, while it is done for non-patent publications. So Tunitin, some softwares like Tunitin are there that are used exclusively for non-patent literature to search for plagiarism, that this should not be copied from any other publication. But this is not done in patent publication. As long as you are able to convince the examiner, you are able to convince the patent office that your invention is different from the invention of the competitor or is different from any of the prior arts, even if you are using the same language as the prior art, then it is still patentable. So in patent literature, you don't need to worry about plagiarism. You just need to worry about inventiveness or the new novelty of the invention that you are proposing. While in non-patent literature, it is very important that you don't use the same words, you don't plagiarize the contents of the prior art. Okay, so this is one of the stark differences between patent application and non-patent applications. Quality check. Patent examination, quality check is patent examination in the case of patent literature and peer review in the case of non-patent publication. So here, this is something what makes patent literature or patents comparatively easier to obtain as compared to non-patent publications. How? Because patent examination is conducted by one examiner and followed by a controller. So there are only two stages of scrutiny in the case of patent applications. As soon as you file an application, it will come to an examiner. Examiner will make a report of it and will forward the report to the controller. Controller will just scroll it, see it, whether the report is okay or not. If he wants to add something to it, he may add something, and then that report is sent to the applicant. So there are only two persons involved in the process of patent examination. While in peer-reviewed journals, there may be multiple reviewers, 3 or 4 reviewers even, to review in the review process of that journal. Subject category, classification by technology field. In patents, all the total inventions are classified into subject matters, and then further classified by a classification system. So I can't go into details of what the classification system looks like, but there are certain classification systems like IPC, International Patent Classification, CPC, Cooperative Patent Classification, that narrow down the searches or the areas of interest or areas of research or areas of patents to very small areas. Okay, so during patent publication, the subject is categorized by the classification of that patent, that this patent belongs to this classification, this patent belongs to this classification. While in the case of non-patent literature, it is just classified, or it is just differentiated by the help of subject field. So if you have a material science paper, then it can be published in a material science publication. If you have a communications paper, you can publish it in the communications domain, and so on. Reason to publish: for patent applications, the reason of publishing is economic or commercial, monopoly, licensing, etc. Basically, if you are interested in publishing a patent, then the motive behind the publication of a patent is to earn profits from it, to earn money out of it. Okay, that is one of the most probable use of getting a patent. While in case of non-patent literature, basically scientific recognition is one of the important things, because of which non-patent publications such as journal publications are done. Published by patents are basically taken by companies and research entities, while the non-patent publication is basically done by universities and colleges, academics. Cost: patent publication fee is required. That fee may vary from country to country and from applicant to applicant. I will tell you what fee you will require if you file a patent. And for non-patent publication, there are fee-based or free. Both kind of publications are there. Both kind of journals and conference papers are there. So there is some cost included in that also. And publication time. In patents, you require, after filing a patent, if there are two kinds of examination. One is normal examination. One is expedited examination. So if you are eligible for expedited examination, the application can be published quite early. But if you are following the normal route of examination, it takes 18 months time before it gets published. So if you apply today, your patent will be published in the patent journal in 18 months time. And non-patent publication depends on the review process of journals. It may take less time, it may take more time. It depends on the review process. So now coming to what patent and why to patent. What to patent? Patent, there are two things that can be patented, as you can see on the top portion of the slide: product and process. So you can either patent a product or you can patent a process. This is defined in the patent set. This is our patent set, and all the law. This is the total law that is followed in India regarding patents. So it has all the clauses, all the subject matters that are needed to be known by people who are applying for a patent or those who are associated with the field of patents. So in this, it has been mentioned that in India, only a product or a process can be patented. So what are products? Products are something that have never been made before. And what is a process? A process of creating something that has never been made before, or a process of creating something in a way that has been never used before. So even if the product is known, for example, you are manufacturing ammonia, or you are manufacturing anything. If you are manufacturing a chemical compound, and you are using a new technology, a new process to manufacture that, and that process is more economical than the present process, then this is also a subject matter of patent. So it can be a new product, or it can be a new process to manufacture an old product. Okay. Second thing to note, invention has to be in some technology. Okay. The basic thing, what can be patented is it should be some technology. If there is no technology involved, then it will not be subject matter of a patent. Why to patent? So if you, this is the definition of Cambridge Dictionary, inventions is equal to patents. So if you don't patent your invention, other people may make all the profit out of it. So why should we get patents? Because you have invented something, and if you don't get it patented, others will use that patent, others will use your patent to make profits out of it. Now coming to the documents required for filing a patent application in India. So there are various documents in the filing procedure. All this process is online. You can go to the website of Indian Patent Office, that is ipindia.gov.in, and in the website itself there is an option for online filing of patent application. You click on that button, and all these forms will have to be submitted by you, which are present online. So Form 1, Form 2, Form 3, Form 5, Form 18, and Form 26. These 5 documents, basically, these 5 documents are to be filed definitely by each applicant. What is Form 1? Form 1 is application for grant of a patent. So Form 1 includes all the details about the inventor, about the applicant, about the previous history of the patent, whether that patent has been filed elsewhere or it is being filed for the first time, the title of the invention, the number of pages in the invention, and the declaration by the inventors that this invention has been made by us and we give the rights of the patent to this particular person. So all these basic form details are in Form 1. What is Form 2? Form 2 is provisional specification and complete specification. We will come just in a bit to this part, what is Form 2. But you just need to understand right now that Form 2 is whatever is the patent part or the technical part of the invention is all in Form 2. Form 2 is technical part of the invention, starting from the title of the invention to the field of invention, object of invention, background of invention, drawings, abstract, and claims. So all these things come in the Form 2. Form 3, corresponding declaration and undertakings concerning foreign patent application. So if you have also filed a foreign patent application, Form 3 is there for you to declare it, that I have filed this patent also in US, also in EP, also in Japan, also in Australia. So that declaration you have to provide in Form 3. Form 5, declaration of inventorship, that this invention has been made by these inventors. This is a kind of declaration that is given in Form 5. Form 18 is one of the most important forms, and it is called RQ form, that is request for examination form. What is request for examination? Even if you have filed an application today, it will not be taken up for examination by us, by the office, until and unless you file a request to the office that please examine my application. That request for examination of the application is provided in Form 18, which has to be filed within a period of 48 months from the priority date or from the date of filing of the application. Okay, so after this expedited examination, there are 2 forms. If the applicant is eligible for expedited examination, he may file a Form 18A. And finally, Form 26 is power of attorney. If the applicant is not filing the application himself and is taking the help of a attorney, patent attorney, or a patent agent to file the application with the patent office, then the applicant needs to grant the right of grant the power of attorney or power of authority to the agent to do all the legal proceedings on his behalf to the agent. Okay. And priority document, what is priority document? We will come to know it in a bit. Now, parts of Form 2. As I already told you, Form 2 is provisional specification or complete specification. So what is complete specification? What are the things that are there in complete specification? Abstract is there, description is there, summary of invention, brief description of drawings, detailed description of preferred embodiments, and claims. Claims can be for device, claims can be for apparatus, claims can be for system. Okay, so device, apparatus, and system are all can be categorized into the product claims. All these are product claims. If a product is there, you can claim that product as a device, you can claim that product as an apparatus or a system, whatever it is. And second is process. So you can claim a process as a process itself or as a method. Okay, so claims are further categorized into two types: independent claims and dependent claims. Independent claims are claims that stand on themselves. What does it mean, stand on themselves? That they don't require other claims to read them. They are sufficient in themselves only. And dependent claims are dependent on the independent claims, and they are they claim the further embodiments of the independent claims. So independent claims, what should be the subject matter of independent claims? It should disclose all the essential, novel, and inventive features of the invention. So if your invention is, if you have invented and you are applying for a patent, there are certain essential features, that these features are essential for making this invention. All those essential features of the invention which have novelty in them, which have inventive step in them, they will be part of the independent claim. So this is how you format. I am telling you about the format of the patent application, that it starts with an abstract and then description. On the top of the description there will be a title के बाद field of invention and background of invention, then summary of invention, then brief description of drawings, then detailed description. Now we are coming in the next three slides I will be discussing what are the contents of each one of them. So role of specification and claims. First, let us discuss the role of specification. The claims define the legal boundaries of invention. Now, if you have filed a patent, so the legal boundaries. Why are you filing a patent? You are filing a patent so that none of your competitors can copy your invention. So what will be copied? What will be the protection that will be granted to you? The boundary of the protection that will be granted to the applicant of the patent is decided on the basis of claims of the invention. So we don't read the whole description of the patent. We read the description, but to decide what is the criteria or what is the limits of the protection that will be granted to the applicant is decided solely on the basis of how claims are found. Okay, so the claims define the legal boundaries. If you think that somebody is infringing on, if somebody is copying your patent, so then you go to the court. Court will decide whether the second party is infringing on your patent based on what claims you have made, and if whatever he is using or he is doing, is he doing something which is claimed inside your claims. So it is very important for when we draft the patent that we understand how to draft a claim, in such a manner that it gives you a very broad protection for your patent application. If you make your claim in such a way that it is very narrow, the scope of the claim is very narrow, then any infringer, any other person can see, okay, this claim is very narrow, I can change one or two things of this claim and I can use it again. So it will be very easy for the infringer, for the him to pirate your invention. Okay. So this is the role of claims. Now, what is the role of specification? The specification describes the invention and how to make use of it. So when you file Form 2, you give a disclosure that the next pages of the description of the complete specification describe the invention completely and fully and how to make use of it. Okay, so I initially told you we want a complete disclosure from your side and we give you exclusive right for 20 years. So the purpose of specification is it describes the invention completely and fully, and it also tells us about the best method of using it. So there are requirements that must be fulfilled when we are drafting the specification of the patent application, complete specification. The three criteria is it should have a written description requirement. It should have a written description. Why written description is required? To demonstrate possession. To demonstrate that actually the applicant is in possession of the invention, a complete written description is required. Second is enablement requirement. Now, how should be the specification? The specification or the description of the invention should be such that it completely covers all the process or all these steps that are required to perform that invention. If you are for filing for a product, for example, then all the application should mention all the steps that are to be followed sequentially, so that if a person reading the patent application starts reading the patent application, he will be enabled, he will be he will be able to understand how to make that particular process, how to use that particular process, or how to make that particular product. That is, your description should be in itself sufficient for any third person to enable to make that particular product or process. Okay, so you should disclose each and everything that is there, so that the third person studying can is enabled to make that product by reading the application itself. And third condition is best mode. Now, if you are entitled to get protection for a patent for a product or a process, now there may be multiple methods by which you can make that process or product. It is necessary that you have to disclose the best method of doing that particular thing. That is, there is a shortcut method, there is a long cut method, there may be n number of methods by which you make that product. So in patent application, you have to give a disclosure, you have to give a declaration that whatever I am disclosing in this patent application, it is the best method of doing this application, or it is the best method of either producing that or producing that product or making that process. So this is the best mode condition of a specification. Now, contents of patent writing. I am just discussing briefly about all of you about patent drafting. What are the contents of a patent, and what are the things that need to be kept in mind while you are drafting a patent? Okay. So title. First, contents of patent writing. First is title. You start with the title. First thing, title should not exceed 15 words. 15 words is the limit of the title, and it shall be brief, free from fancy expressions or ambiguity, and as precise and as definite as possible. So it should be precise, it should be definite, it should not have any fancy expressions, it should not have any advantages, it should not have any ambiguity in it, it should be brief. So for example, if you have invented a camera, okay, so you can just if you are invented a camera and that camera can be used in night mode, so the title of the invention should be as brief as a camera for use at night, or a night use camera. So these 4 words are sufficient to describe briefly what your invention is about. Second is field of invention. Just after the title, the first heading will be field of invention. What field of invention tells? That should tell the advantages of the invention and provide evidence to support industrial applicability. In field of invention, basically we give the broad field of invention. So if you are inventing some antenna, for example, so you can write it there that this the field of it belongs to the field of wireless communication using this kind of antenna. So this will be the very broad field of application, broad field of technology that your application belongs to. So your application belongs to wireless communication technology. So the field of invention will be an antenna for use in wireless field of technology, near field or in far field. तो near communication के लिए है कि far communication के लिए है, और वो antenna आपने बनाया है तो it definitely is for wireless communication. So this will be the brief of field of invention. Now again, next is background of invention or prior art. So in non-patent literature, literature, it is identified as literature review. So literature review and background of invention is one and the same thing. It is same as literature survey or literature review. what are the contents? It describes the invention by clearly distinguishing it from a closest prior art. So in all the patent applications, this section has what are the prior arts, what are the problems in the prior art, and what are the possible solutions that have been proposed by previous prior arts, and what are the drawbacks of the previous solutions. So whatever we discussed in the previous slide about understanding patent application, is understanding applications, all those things are present in the background of the art. Okay, so if you want to understand a patent application, just go to the background of the invention. Background of the invention mein, first thing that this is the problem कि हम ये use करते हैं. For example, in modern telecommunication, in modern transporting, ambulances can't go through the lanes, so there is a problem or delay in transportation of patients through ambulances. Now this is a problem. This is the problem statement. Now there are various solutions provided by the prior arts. These are the solutions. These are the 1, 2, 3 are the solutions. And what now among these solutions, these are the drawbacks of the solutions proposed by the prior arts. And after that, we will discuss about now. I am disclosing a novel and inventive method or novel and inventive system of managing the ambulance traffic or managing the traffic so that ambulances can be passed rapidly. तो इस तरीके से आप बैकग्राउंड ऑफ इन्वेंशन प्रेजेंट करोगे. बैकग्राउंड ऑफ इन्वेंशन में प्रॉब्लम स्टेटमेंट क्या है, व्हाट इज द प्रॉब्लम स्टेटमेंट, व्हाट आर द सॉल्यूशंस प्रपोज्ड इन द प्रायर आर्ट, व्हाट आर द ड्रॉबैक्स ऑफ द proposed solutions, and how you are overcoming that drawback. Now objects of invention. Next heading shall be objects of invention. It shall clearly mention the technical problems associated with the existing technology and the solution for that, and bringing out the differences between the claimed invention and the prior art. So in this section, you will start with the object of the invention is to provide this, which is better than this, and how it is better. So now you will start differentiating your invention, your novel and inventive invention from the prior arts. That now the object of the invention is to present, is to disclose a system or is to disclose a process that is better than the prior art, and how it is better, that it is different from the prior art in this things. Now contents of patent writing, summary of invention. Next is summary. Summary should include a summary of invention before getting into the details of invention and the method of performing it. So it will be kind of an abstract kind of thing that you will briefly describe in one or two paragraphs what your invention is. Again, next will be brief description of drawings. Now, if you have used drawings and you have named figures as figure 1, 2, 3, 4 up to 10. Now, this brief description of drawings will be 1 or 2 line description of the drawing. For example, figure 1 is the 3D model of the proposed dash. So this will be the brief description of drawings. Again, the next will be detailed description of the invention. In detailed description of the invention, it is required to be furnished with sufficient detail so as to give a complete picture of the invention. So in this, you will to start with figure 1. So figure 1 is the basic block diagram of the system proposed. In figure 1, now you have to use reference numerals in the figure. Figure 1, part 1, 101, 102, 101, 102, 103, 104 are these parts. Now these parts are interconnected by a bus, by a microcontroller, then this. So this will be the detailed description of the invention. Now next is claims, very important part of patent writing. And claim is a statement of technical facts expressed in legal terms defining the scope of invention sought to be protected. We have discussed what is the use of claims. So claims are, you have to keep in mind, claims are complex words because they are legal terms, and claims define the scope of invention or for which the protection is sought. That this is the limits or this is the scope of protection. Anything that lies outside the scope of protection, outside the scope of claims, is not protected. So you have to understand that you have to frame your claims in such a way that it is sufficient to cover your invention and no other person can take advantage of your narrowness of the claims. Okay. What is not claimed? Okay, one very important point. What is not claimed in the claims stands disclaimed and is open to public use even if the matter is disclosed in the specification. What does it mean? It means that if you have done n number of things and if you have claimed only one thing out of it, if you have in the complete specification, in the description, you have given a detailed description about 3 or 4 types of things that you have invented, but you claim only one particular thing out of those, then only whatever is claimed is getting protected. Other things that have been disclosed in the description are not protected. Anybody is free, it is free for public use, anybody can copy it. So if you want something to be copied, make sure that it is not sufficient to disclose it in the description. The same thing should also be present in the claims, because the scope of protection is only determined by the what is claimed. What is not claimed is unclaimed. Contents of patent writing continued, that is figures. Next is figures. After detailed description of drawings, now the description is over. Description is over. What is left is abstract and figures. So there are certain things that you have to keep in mind about the legal requirements, that there should be a boundary of 4 centimeter on the top and left side and 3 centimeter at the bottom and right sides. Drawings should be signed by the applicant or agent. Drawings should not, nothing should be written on the drawings. No text should be there. Only reference numerals should be there in the text, etc. In the drawings, etc. So all these are requirements of figures. Abstract should not be more than 150 words. It should tell what the field of invention, the technical problem, and the solution to the technical problem. So it should be brief, up to 150 words. It should not be very ambiguous. Should not be using words like it is very novel, it is very unique. Okay, so these kinds of words should be avoided in framing of patents. It should be very precise. It should be 150 words. It should start with the field of invention, the problem statement, and the solution that you are proposing. It should also tell the end users of the innovation, whatever you are making, who it is beneficial for, who will be the end beneficiaries of your innovation. It should also be mentioned in the abstract. So this was about the structure of the patent application that you have to draft. Now, how to start drafting? It's just basic tips I'm giving you. Draft a set of claims first. Now, when you start drafting, now the thing is you are already acquainted with non-patent literature. You must have finished a lot many applications or many publications in journals and conferences. So how to convert those journal and conferences to patent applications? So first thing you have to keep in mind, start with claims. First, identify what your invention is. First, identify the problem statement and the solution that you are proposing. And based on the problem statement and the solution, first set of claims, make a set of claims. Draft a set of claims first to define the invention. It requires an understanding of the content of prior art and an understanding of what makes the invention patentable. Do a prior art search, that is required. The specification is then drafted in view of necessary content. Now, whatever claims you have formed first, this will be called the first draft of claims. This is the rough draft or first draft of claims. Based on the draft of claims, now you start writing the specification and try. It is one of the basic requirements in Patent Act that the claims must come from, or claims must be supported by description. So make sure whatever claims you have drafted, all that content of the claim should also be present in the specification. So you can copy the contents of claim in the specification so that whatever is present in the claims is disclosed in the description. Okay, and keep one thing in mind: first drafts don't have to be perfect; they just have to be written. So once you start drafting the claims, it's not possible and it's not necessary that the first draft of claims that you are drafting will be perfect. So you make a first draft, then you write the specification, then you see that there are some changes that need to be made to the claims, then you make a second draft, then you make a third draft. So it takes many drafts, 5-6 drafts before you get a perfect claims for your patent application. How to write a patent? I'm just giving you brief tips because it's not possible to cover drafting of claims in such a short time. Conduct a thorough prior art search. because you are filing for a patent application, and my task and the task of the patent office is to search for prior arts that are similar to your invention. So first make sure that your invention is patentable. It is not something that has been disclosed, similar things that have been disclosed in other prior arts, because then your patent will be rejected. Second, draft broad claims. The scope of the claims is defined under section 10(4)(c). So in this act, in section 10(4)(c) of the act, the scope of claims is defined. So I already told you, claims ko broad karne ki koshish karo. It should be kept in mind that as broad as the claim should be. For example, I'm just giving an example. If you have made an invention of a pen, for example, a pen. So if you are writing a pen, if you are writing an ink pen, so the scope of the claim is just narrowed down to ink pen. Now, if you remove this word pen, then you are broadening it to a certain extent by including a ball pen, an ink pen, a roller pen. All kinds of pen will be included if you delete the word ink pen. So you try to broaden the scope of the claims. Don't use the word ink pen, use the word pen. Again, if you want to further broaden the scope, what you can use a writing equipment. You can use the word, phrase writing equipment or writing instrument. So when you use the word writing instrument, what all the things can be included? It can also include a pencil, it can include a pen, it can include a brush. So there are n type of things. It can include an electronic pen, etc. So this way you have to keep in mind that patents, it's always beneficial to draft broad set of claims. Okay. Third thing, align claims and specification. As I already told you, it is a requirement under section 10(5) fair basis. That means whatever is claimed in the claims, that same material should be present in the description also. So align claims and specification. It should not be such that claims are different, specification is different. They should be matching to each other. Stack your claims. Fourth is stack your claims. What is stacking of claims? Multiple independent claims to cover different embodiments. What does it mean? If there may be multiple independent claims. If you have made a system, for example, you have made a communication system. Now communication system has two things: one antenna, okay, one transmitter and receiver. So what you can do is, first independent claim, a system for communication, a system for broadcast communication, a system for one-to-one communication. This can be first claim. Second independent claim can be a transmitter for communication. Third claim can be a receiver for communication. So what you are doing is you are stacking claim by claim, so that even if somebody wants to copy first claim, somebody wants to infringe first claims, there will be so many claims that he will not be able to infringe your patent. So stacking of claims is something that you should always make it a practice in claim drafting. Fifth point, clarity is critical. In clarity, there are 3 points: detail, ambiguity, and grammar and spelling. Now what about detail? You have to go into details of your invention. You have to disclose your invention in such a way that any person skilled in the art, any person who has a fair knowledge of that art, must be able to read, must be able to perform that invention by reading your application. So it should be in sufficient detail, but don't go into so much details that it will be very easy for him to make it. So there should be a balance between too much detail and too less detail. It should be sufficiently detailed. Ambiguity, don't use words that are ambiguous in nature. Ambiguous means they are not clear or they are not precise. So try to be very clear, try to be very precise to the point in drafting of claims. And grammar, spelling, keep in mind that grammar and spelling can sometimes change the meaning of the claims, change the scope of the claims too much. So always it's preferable that you show it to someone for proofreading who has a good knowledge of English. Okay. 6th point, take help of a professional if necessary. Claim drafting and application drafting is sometimes difficult for students and teachers who are in academic institutions. So it is, if you are not able to draft a good claim, if you don't have a practice or you don't have time, take help of a professional. And 7.1 important point is do not compare prior arts. I will emphasize this because in non-patent literature we have a habit of comparing of prior arts. That in this paper, in the paper of Murakami, this has been discussed. All the previous other authors, you compare the your task with the art of the prior arts. Don't compare here. You have to give a background of the invention, but in background of the invention, don't mention specific patents. Mention that this was the problem in the example that I took in the prior ambulance, for the passage of ambulance. This is the problem. Now many in the literature have provided these solutions. So you can mention the solutions, but don't mention specifically the patent applications or non-patent literature that you are using for comparison purposes. Okay. So that the examiner that will be reading, it will be very easy for him to go to that particular prior art, and then he will see that you have made a small difference from the prior art, and he may come to a conclusion that you have not done sufficient. He can assume that there is just a small amount of modification, a small amount of improvement, which is not inventive, and it may be formed as a basis for rejection of your patent. So don't compare prior arts in the background of invention or anywhere else in the description. Just give the background of the invention, the solutions in the prior art. Now, provisional specification. One important thing: if you want to file a patent, you have published a non-patent literature, you have a journal. Now, what you can do, you have one year of time before you file a complete specification. Now, if you are not ready to file that specification yet, what you can do, in complete specification, you need to file claims. You need to file it should be a complete specification as the name suggests. So you are not prepared yet to disclose the complete specification to the patent office, to submit it. Now, what you can do, you can submit a provisional. Provisional is temporary kind of a thing, provisional specification without claims. And then the office provides you a time of 1 year, that is 12 months, before you can file a complete specification. Okay. So it is always advised that if you have an idea, and if that idea is at a maturity level that it can be put on paper, so put it on paper, provide some drawings, and submit it to the patent office. You will be given 1 year of time, 12 months of time to file a complete specification. Take that time, draft the patent in a very professional manner by drafting the claims properly in a clear and concise way, by drafting the drawings, by drafting abstract, etc. So what will be the benefit? That, for example, you invented something today, and if you are not ready yet with the complete specification, you file a provisional specification today. Tomorrow, it may be possible that one of your competitors can file the same application. So in that case, if you have already submitted a provisional specification today, you will be granted a protection for your patent from this provisional specification date. So the other person who is also doing R&D on the same field will not be able to publish it before you. So for taking the protection of date, it is always advised to file a priority application or a provisional specification before even filing a complete specification. It is analogous to learner's license and driver's license. Now, expedited examination. Expedited examination, there is in recent amendments in the Act, the Government of India has decided that startups, small entities, that MSME companies or departments of government and other government establishments, etc. There are certain categories of applicants that can file for expedited examination. Expedited examination is a fast way of application examination, in which it is hardly 6 months to 1 year time in which your patent is granted. Normal route of patent granting may take somewhere from 3 years to 4 years, while this method takes a time of up to 1 year. So it is very fast. But who can apply for this? If the applicant is a startup, if the applicant is an MSME, if there are multiple applicants and one of the applicants is a female, if the institution is a government or other government organization, if India has been selected as an ISA or IPA in PCT, or an agreement between Indian Patent Office and a foreign patent office is there, in that case also. So you can refer to the Patents Act 2003 for further details on who can file for an expedited examination. What is the fees for e-filing in rupees? So for an educational institute, because you are an educational institute, if MITS Madanapalli decides to file a patent, the form for a patent is only 1600 rupees. No fees up to 10 claims, no extra fees for 10 claims and 30 pages. If claims exceed 10 claims and pages exceed 30 pages, there is certain amount of fees like 320 rupees per page and 800 rupees per claim, 400 rupees per claim or 800 rupees per claim that needs to be filed. And Form 18, that is request for examination, fees is 4,000 rupees. Total 5,600 rupees fees is sufficient for an educational institution to file for a patent. And if other than an educational institution or a person or a startup or a small entity, all other big companies pay a fees of about 28,000, as you can see. So you can see that government wants all educational institutions to file as many patent applications as possible, and it has also reduced the fees by 1/4, almost 1/4, so that it is not a burden for all of you. Filing procedure, as I told you, there are two modes of filing: offline filing and online filing. Offline filing, you can go to patent offices. There are 4 patent offices in all 4 metro cities: Chennai, Delhi, Kolkata, and Mumbai. And online filing is also there. You just go to ipindiaonline.gov.in. There is an e-patent filing portal there. You go, you log in there. It requires digital signature class 2 or 3 for filing of this online patent application. And what is the procedure that is followed for patent filing? You file a patent, then this is the normal route. I'm not talking about the expedited examination. This is normal route of filing. Patent is filed, it gets published in 18 months. After publication, if the request for examination is filed, whenever the request of examination RQ is filed, it is taken up for examination by the examiner, and examiner generates an FER, first examination report, is generated by the patent office. That report is sent to the applicant. Now applicant is given a time of 6 months to reply to the objections of the patent, the objections in the FER. So he will submit a FER response within 6 months. Now, after the reply by the applicant, that reply will be considered by the office, and a second examination report will be generated if it is required. If all the objections, if the examiner or controller feels that all the objections have been met, at this point only the patent can be granted. If there are objections, pending objections, then a second examination report will be generated by the office, and then after second examination report, the office will decide to take a hearing. So hearing will be between 2 parties, that is the applicant and the office. The controller from the office and applicant will sit in front of each other. It may be online hearing or offline hearing, and after hearing, there will be definitely a decision will be taken about either grant or refusal of the patent applications. So this is the flow chart of how a patent application is processed in Indian Patent Office. What do you mean by patent search? Now we are coming to search. So patent search is one, prior art search or patent search is one of the basic things. Before filing for a patent, I told you it is very much required that you go to, you search for prior arts. For searching of, why should we search? Search should be done to see that if the patent is patentable, if the invention is patentable, or if it is not patentable, and to what degree it is patentable. It may be that 50% of the patent is patentable or 50% is not, or 50% chances are that the patent will be granted and 50% is that it will be refused. So a search may help inventors to modify their efforts to improve the probability of getting a patent. Now, for example, computer CRI inventions or computer related inventions, computer programs are as such not patentable in India. Now you as an inventor have invented a computer program. If you are able to conduct a search, if you know how to search, you will know that computer programs cannot be patented. Now you can modify your efforts. You can add something to those computer programs. You can add a method in such a way that now it will be patented. So it is always beneficial to search, so that if you find some similar art, similar prior arts, then you can modify your own patent application in such a way that the chances of grant of your patent application increases. Have you been searching publications? Yes. Google the title or important keywords of the paper, searched on journals or transactions website. For non-patent literature, you have been searching by Googling important keywords for the paper and searching for journals or transactions website. So did you get the satisfying result? How much time have you spent on searching? No, sir, I spent most of the time studying searched papers which were found irrelevant later. How to get better results? Well, so you must have felt this as a problem, that when you search, most of the times you end up by results which take a huge amount of time, and when you read those results, you see that those are irrelevant to you. They are not matching your own invention. So how to search quickly? So patent search strategies. I will share with you in the slide 2 search strategies that will help you make searches fast. First is searching by keywords and classifications. Second is searching with Boolean logic, proximity, and wildcards. Third is searching by metadata, inventor, assignee, date, etc. Searching by patent or application number. So these are in patents. There may be these 4 kinds of patent search strategies. But for students and for academics, first two kinds of patent strategies on slide are sufficient. First is searching by keywords and classification. Second is searching by with Boolean logic, proximity, and wildcards. Now, if you want to make it very efficient, what you can use is you can use a combination of 1 and 2 searches. That is keywords and classifications plus Boolean logic and proximity and wildcards. If you combine these two, it will be very easy, very fast, and you will get appropriate results for your search. Okay, so in the note it's written 1, that is keywords, and 2 can be used in searching. Okay, 1, 3, and 4 can be used for patent searchers. So you don't need to go for 1 and 4 because that is for patent searchers, professionals. For academics people, 1 and 2, combination of 1 and 2, that is keywords and classification search, when combined with Boolean logic, proximity, and wildcards, will give you good results. Where to search for these? Google Patents, WIPO, USPTO, EPO, eSpaceNet, and IPO InPass. All these are free databases. All these are databases provided by different organizations. For example, Indian Patent Office InPass is there. It is again on this website of ipindiaservices.gov.in, IP India's website. WIPO is World Intellectual Property Organization. So Patent Scope is WIPO's website on which you can search. USPTO belongs to US Patent Office. EPO belongs to the European Patent Office. All these are, you can search for, these are the URLs given to you. You can go to any of these websites and search for free using keyword search and IPC search. Now Google, I am just showing you the page how the Google patent search looks like. So in this, there are search terms. I searched for this PID controller or regulator, PID near 3 controller or regulator. So that search term is present on the left side, as you can see, and date of publication, that I am searching for publication from this date to this date only. Okay. So the results, as you can see, about 1,35,828 results are there, and they are sorted by relevance. Okay. So on the top of the slide, you can see there are 2 buttons. Both are highlighted in blue. That is, first button is bulb button, and the second one is the cap button. So this first button stands for patent literature. Second is non-patent literature such as journals. So if you want to conduct a search in which the Google patents will provide results of both patent and non-patent literatures, you have to click both of them on. If you want only patent literature, this first button should be on, second should be off. If you want only non-patent literature, this should be on, this should be off. Okay. So this is how you conduct a search. And to make a query, I am in the slides, syntaxes, examples, and have been discussed. So I told you with keywords and with IPC, if you use Boolean operators, proximity operators, and wildcards, it will give you good results. So Boolean operators such as and, or, not are used. For example, sanitizer and dispenser. If you are using word, both these words will be searched. Sanitizer or disinfectant if you use this word or this word. Now proximity, I'm just discussing briefly about what in Google patents, these are all syntaxes of Google patents. So for Google patents, proximity near X, near 3, near 4, near 5 can be used in any order. So if you are using sanitizer, near 3 sanitizer, then these two words, for example, we can use hand near 3 sanitizer. So hand near 3 sanitizer will search all the documents in which the word hand and the word sanitizer are there with a difference of 0 to 3 words in any order. ADJ adjacent X in same order. So hand and sanitizer, yeah, sanitizer dispenser, if you use with ADJ 3, then sanitizer should be the first word, dispenser should be the next word. They should be in the same order. And the difference between these two, or distance between these two words, can be 0 to 3 words. And wildcards are also there. For example, star mark, asterisk sign. Asterisk is therefore number of characters greater than 0. So if you are using this as SANITIS and asterisk, then all the words that have these words will be included in the search results. That is sanitizer, sanitized, sanitizing, sanitization, etc. Okay, so all these wildcards, where you can find all these wildcards, when you click on Google in the search terms, if you click here, Google will provide you a help of what the syntaxes are, what the wildcards are, and you can read here what are the syntaxes and wildcards, and you can use them yourself. So now I'm due to lack of time, I'm not going into how to conduct a search. Otherwise, I could have shown you how to search. So these are various queries that you can put in Google Patents. For example, this was the example that I was taking: PID controller regulator tuning genetic algorithm process control optimization. So PID controller, which uses genetic algorithm, and this genetic algorithm is being used to control the process control. So this is how you write a search query. Now you will get some results. Search query until you get good results. So this is how you modify your search and refine your search until you get your final results. Now, research practices to manage disclosures. This was the 9th and second last point that is very important for all the academicians. First thing, keep in mind, patent, then publish. It is advised that if you have some certain novel invention, novel idea, first get it patented, first apply for a patent. After filing for a patent, then you can publish it anywhere else, such as journal or conference papers or any seminars or webinars. Don't reveal enabling details. That is example in abstracts and posters. Enabling details are those details which enable the other person to make that invention, to perform that invention himself. So even if you are disclosing some invention to other person, you please hide the enabling details of the invention from that person, from the poster, from the conference, or so that the other person, even if he or she listens to you, copies you, he will not be able to perform that invention. Do use confidentiality agreement in dealing with outsiders. If you are going to a patent agent, if you are going to a company to discuss your own idea for investment, etc., you can use confidentiality agreement. That is, whatever is being discussed between you and the other party, that shall be confidential, and nobody else can be. That should not go to anybody else. And mark critical enabling details in grant applications as confidential. So you can mark certain enabling details in grant applications as confidential, so that confidential clause is applicable to them. Now, finally, Global Innovation Index. In last 6 years, as you can see on the right side, from 2015 to 2021, we have grown 35 places. India stood 81st in innovation in 2015. Now in 2021, we have come to a rank of 46. So we have progressed a lot in the last 6 years. Hopefully, we will improve a lot further in the coming years with the help of all of these young professionals and students. State-wise patent application filing, as you can see, maximum patent application filing state-wise is in Maharashtra, Tamil Nadu, Karnataka. So it is our imperative, and the government wants that those states which are lacking behind in innovation should also come forward and file for more applications in the coming days. Top Indian applicants for patents from academics. Which academic institutions, colleges file for maximum patent applications? You can see all the IITs combined collectively file for 664. Lovely Professional University, LPU 4442, Chandigarh University 400, and so on. So there are some SRM College of Technology 56, and MIT University 179, and so on. Top 10 foreign resident applicants. These are MNC companies that have offices in India also. So among them, top 10 are Huawei, Qualcomm, Samsung, Oppo, Ericsson, Microsoft, Philips, Honda, Alibaba, and Signify Holdings. This is just a screenshot of the IP India website. So in the IP India website, as you can see, patents, designs, trademarks, GIs, etc. All these options are available. You can either file for a patent application. For example, comprehensive e-filing option is there, as you can see highlighted in orange. So if you want to file a patent, you go to this comprehensive e-filing. If you want to conduct a search, you go to public search. If you want to read something like acts and rules, manuals, etc., you can go here. So all the details about patents and the related things in India is present on this website, ipindia.gov.in. That is the website of this office. So this is the last slide, and by the way of this slide, I'm completing my presentation here, and now the floor is open for questions and answers. Everything is theoretically impossible until it is done. It is one of the famous quotes from Rocket Boys, a recent series that we saw on Sony. Thank you.
Okay, thank you very much, sir, for sharing such a valuable information on IPR and patent filing, sir. So we have come to know a new aspect through this session. So participants, if you are having any query, you can put that query in the chat box.
Hello, sir. Is my voice audible?
Yes.
Yeah, please.
Sir, I have a specific question. Recently, I'm a faculty here at MITS. We have filed a patent, sir, and we also got the first examination report.
Okay.
But the number of inventors are 4 people, and we opted them as the applicant also.
Okay.
We have not mentioned the college as an applicant, sir.
Okay.
Now, at this point of time, how can we add the college as an applicant?
Okay. So you can file for it will be accompanied. There are forms for filing of a patent application. So if you want to add an inventor, there is a separate form. If you want to add an applicant, there is a separate form. So yeah, so you have to apply for a form 6. Form 6 is for changing of an applicant. So there is no separate form for addition of a new applicant. So what you have to do is you have to apply for form 6. There is a fee of about 4,000 rupees, I think, for changing the applicant. So you filed and you mentioned there that there were 4 natural persons applicants previously, and now it is being changed to 5 persons, 4 natural persons and 1 institute. So in that way, by filing of form 6, I think it will be possible.
Sir, what about this form 28, sir?
Form 28 is for it's a recent form that is mandatory for filing of applications for startups, for natural persons, for MSMEs, and for educational institutions, etc., who claim the benefit of expedited examination. But as your institute cannot file for an expedited examination, you don't need to file for a form 28. Form 28. Sir, actually, yeah.
We have a female candidate, so we can file
examination. Yeah. In that case, form 28 is required for. You have to file form 28 with each and every document that you file with the office. So if you are filing,
can you just elaborate it, sir? Like now at this point of time, what we can do? We can file form 28 then.
No, you have to file form 6 for changing the applicant. So along with form 6, it is mandatory for you to also file form 28, because form 28 is accompanied with all the forms that you submit to the office. So form 6 plus form 28 you submit to the office with the prescribed fee. Your work will be done.
Okay, sir. Got it, sir. Thank you. Thank you very
Have
much.
you filed the application on your own or with help of some agent?
On my own, we have done.
Okay.
Okay, and one more thing, because the applicant has increased, now you will have to, there will be changes in Form 1, changes in Form 5, changes in Form 18, etc. So all the forms will have to be submitted fresh. Okay.
Okay.
So
Sir,
that,
or else,
what?
or else, is there anything to assign the rights to the institution? Is there some procedure like that?
No. So yeah, definitely. Once you are granted a patent, then you can license the rights of the patent to anybody. You can sell the patent. You can assign the rights. That is not governed by us. That is not governed by patent office. That is
Okay.
a matter of normal legal practices. But
Okay,
if you
fine.
want that the applicant should be mentioned, or the name of the applicant should be mentioned, the name of the college should be as mentioned as applicant. In that case, you have to file Form 6.
Understood, sir. Thank you.
Thank you.
Okay, any question from the participant?
Sir, one last question.
Yeah.
Sir, is there any plagiarism check that you use to check for plagiarism in the patents documents? Is there any software that you use?
No, we don't. As I told you, we don't use any plagiarism check software in for patents. Basically,
Okay.
in patents, we have certain qualifications or certain requirements that must be fulfilled before we grant a patent. Those qualifications are that your invention should be from a patentable area. Certain things are non-patentable under the Act under Section 3. So it should be patentable subject matter under the Act, under the Patent Act that we follow. So if that matter is patentable, then we see that it should have novelty, it should be inventive, okay, and it should have industrial capability or applicability. If these criteria are fulfilled, it is novel, it is inventive, and it is industrially applicable. Even if you have copied it from someone, it can be granted. We don't go for plagiarism check. The focus is technology. The focus is on the technology that you are implementing. The focus is not on the words in English language.
Got it. Okay, sir.
Thank you.
Okay, any other questions from the participant? Participant, you can put your queries in the chat box. Okay, sir. So I think there is no question from the participant. So Mahesh sir, can I conclude the session?
Yes, sir. Please do that.
Sir, please conclude.
Okay. Okay. So with this, I would like to conclude the session. Thank you very much, sir, Mr. Soumyaranjan sir and Dr. Kausik Bagh sir, for sparing valuable time and delivering such an inspirational and wonderful session. So I hope, sir, in future we also, sir, take your help for those type of patent and all those things. So I also thank to everyone for making this session successful. So thank you all of you. Thank you very much, sir.
Thank you, sir. Thank you, Nanda sir. Thank you. I thank all the organizing committee members of Department of EC MITS Madanpalle for organizing and for giving us this opportunity to discuss with students as well as faculties of your institute about basic IPR and patents, basics of patents. I think I hope that this session was helpful to you to understand and to be more knowledgeable about patents. And I hope that this is fruitful in terms of filing of more patent applications from your side in future. So thank you for sparing your valuable time to us, and hopefully we will meet again with another session on IPR. Thank you for joining the session. Let's conclude the session at this note. Thank you very much.
Thank you.
Okay, thank you very much, sir.
Thank you.
Okay, so participants, we have another session at 2 o'clock sharp. So we will meet in this session. Okay, thank you very much.